Hi, my name is Heather Hewlett. I'm the Director of Client Advocacy at Christian Legal Clinics of Philadelphia, and I am here tonight to talk to you about estate planning, which is a large part of our practice. It's a hugely important part of our practice, and as we dive in, we'll find out why. So I'm going to go ahead and share my screen, and we will jump in. All right, so first, some definitions. So when we say the word estate, everything you own when you die. However, when we say the word estate planning or the phrase estate planning, it's actually a little broader. You're planning for the disposition of your property, your estate after you die, but you're also planning for the management of your health and finances in the event you become incapacitated. We probably all know people that are caring for aging parents who have dementia, Alzheimer's, various other health problems that either limit their mobility and their ability to take care of everything on their own, or limit their capacity. And probate, which we're not going to dive into in this training, is the process of dealing with the estate of someone who has died. It's sort of the other side of the coin. So as we talked about estate planning, what we're trying to do is really plan for easy probating on the other side. So what we'll cover is wills, healthcare power of attorneys, which include what's called a healthcare directive, sometimes referred to as a living will, and financial power of attorneys. Before you get too scared about writing, these are all covered in templates. We have some wonderful attorneys in our network who do estate planning for a living. And so we have some really great templates that for 90% of our clients, they don't have to modify at all. The language, we just plug in their information, and all the language is there, so it doesn't require a lot of original writing. Why it's important, I think I said at the beginning, this is a hugely important part of our practice. And the reason it's important is because it reduces conflict. You probably know people, I have neighbors who haven't talked to brothers in 10 years because of spoons that mom had, and she knows mom would have wanted her to have them, but they're in dad's house or the brother's house, and it's caused this 10-year-long rift, right? And you've heard other things, I'm sure. So when you're talking about that, that's an example of why you want to put something in a will. But let's say healthcare planning, right? Single parents on life support, she can't say what she'd want to happen, but her 2 adult children have very different ideas about what mom would have wanted. One thinks she wants to remain on life support, the other thinks she want to be allowed to die, right? That's a huge conflict that could have been prevented by a healthcare power of attorney and healthcare directive that said, hey, here's the treatment I want in the event that this is what's happening to me. It minimizes uncertainty. So our clients will often have a primary home and multiple children, right? So who does that home go to? One of the children will often be living in the home while the other 2 are not. So we see the situation often that there's multiple siblings, a deceased parent, and one of those siblings is living in the home, has lived in the home forever, raised a family there, but has no certainty because there's these 2 other heirs who also could take title, and they're not working together. There's no plan, there's no will saying how mom would have left that house, what she meant to happen with that house. So what happens is maybe Etta, in this example, lives in the home till she dies, but she can't leave that home to her children now because it's not titled to her. So it ends up getting lost. It ends up being a property that doesn't get passed down in the family. Same thing happens with bank accounts. If it's not clear who's supposed to get it, who's in charge of splitting up the money, often it gets left behind. Or siblings accuse each other of all kinds of things in terms of what was there and who took it, who was allowed to take it, because there was no plan written for who should get it and how much. It reduces opportunity for fraud and abuse. When there's a bunch of properties titled to dead people, it is really easy, especially in Philadelphia, maybe other places have a different system, but here, if the deed, if it passes muster and it looks right, and it has all the right parts, maybe the grantor that signed it was deceased, but they don't know that when they go to record it, right? So if nobody says anything, that deed counts, even though the person who signed it and granted it to this person is deceased. They don't know that at City Hall. The deed gets recorded. The new owner might flip the house, make loads of money, and that house no longer passes down in the family the way it was intended because there wasn't a plan written down. And estate planning allows aging individuals to give powers to trusted people who can act on their behalf when they can't. So we think about financial planning or healthcare planning, right? Even though medical providers should talk to family members and should talk to spouses, there's a statute for that. They often don't. They'll often say things like, you don't have the authority. I can't share this information with you. We had a case, and this is an example, the adult daughter of a bedbound parent with dementia was unable to speak with mom's treatment providers to advocate for her to get more nursing hours because she didn't have, they told her you don't have the legal authority. And so if mom had had a power of attorney in place, she wouldn't have had that same problem. So how we assist with these problems is that we help people do estate planning documents, the wills, the healthcare directives, the power of attorneys for finances and healthcare. And we also help people probate. We assist people who have inherited property by helping them navigate the probate process, connecting them to funding sources to help them with the cost, and writing and recording deeds reflecting the transfer of property from the deceased person to the heirs. We're not going to cover that in this training. There will be a training on that on our website very soon. Okay, so creating a will. So we're going to go to our template. Most of our clients are working with fairly small estates. I think I said this earlier. The estates are simple enough that usually you're just plugging in the language into the template and you're not inventing and modifying it. There's not usually a need to. And when there is, we're here to help. We don't always have to deliver the will during the clinic. Sometimes we have to say, hey, I'm gonna get this back to you because maybe we need to do some more stuff to it. But 90% of the time our templates cover our clients. So we're gonna switch gears and I'm gonna share our will template. Always fun trying to find where you're going. All right, new share. Let's go to our will template. So our testator here, the testator or testatrix is the person writing the will. So our will template is long, it's 22 pages. However, the will itself is like 4 pages. So our will template includes instructions. You're going to talk to them about what to do, but this is for them to take home. They have instructions. So if they're in our office and the will is completed, they're going to do the signing and the notarizing right there in the office. But maybe we're doing this virtually. So we need to give them the instructions for how to make this will effective because we may not be there for that part. So we're going to scroll past the instructions. We talk to them about where you keep the will. You want to keep your will someplace where it can be readily found. I'm in a case right now where everybody says grandma had a will. Nobody can find grandma's will. It's also a good idea to give a copy of your will to the heir. So if you're naming daughter, son, cousin, neighbor as heirs, give a copy of your will to cousin, son, daughter, neighbor, so they have a copy of it. You'll need the original to probate, but at least they know that there is a will that exists and there is a way to probate a copy of a will if that's all that you have. Executors, whoever you're designating the executor, they should have a copy of your will. All right, so we're gonna get down to the will. This is the template. Will of Snow White, right? You're just filling in these blanks. So in our template, the capitalized language is what you're filling in. She has very creative names for her children. So we have folks name their children on the will because maybe they want to write their children out. So maybe Grumpy Grits was too grumpy and she didn't want to leave anything to Grumpy Grits. By naming all of her children, she's saying, hey, I know Grumpy Grits exists. I did not forget him. This was not an error or a mistake. I have all these children, I acknowledge them, but I'm only leaving everything to, well, she doesn't have a happy child. She has a hungry, sleepy, and a grumpy child. So maybe she's going to leave everything to Hungry Hippo because he eats a lot and he needs stuff. So by naming other children, it makes it clear there's not an error. Generally, people are just splitting up their entire estate, their residuary estate into equal shares. This language per stirrups just means that if she's leaving it to Hungry Hippo, Sleepy Sound, Grumpy Grits, and they have children, if Hungry Hips dies, his share would go down his branch. Same with the other descendants. This is also under this section, part 5, is where you'd put any specific bequest. So the fellow we had who had tools and the truck and some various other items, we put that here, the jewelry, the family heirlooms, the furs, the clothes, those kinds of specific requests would go under here. Houses, we would put that under here. You name your executor. We encourage folks to have an alternative executor. So the executor's job is to execute, right? The will is the plan. The executor is the person who's supposed to go do that plan. And so you're picking usually you're picking an heir. You're picking the heir that you trust to be the one to do the thing. Pick someone local. It's hard to probate if you're out of state, if you're out of county. So you're usually picking a local person, and it's always good to choose an alternative in case the Grumpy Grits moves to Arkansas. You would have a Philadelphia-based person as your alternative. All right, so all this language is already here. You're not rewriting it. They sign it with 2 witnesses. If we're doing this in person, we will notarize this for them. And then we give them instructions. So a self-proving affidavit is, if you just have a will and it's witnessed by 2 people, that's fine. But then after you die, when they're probating, the 2 witnesses will have to come down to City Hall and say, yes, I saw so-and-so sign the will. So now the heir has to go find those witnesses, make them do stuff, make them come down to City Hall. Sometimes those witnesses are older by the time you're probating, and that can be really difficult. Sometimes they've moved, right? So it can be a barrier, whereas a self-proving affidavit, which is our default way of doing wills, is a notary is there witnessing the signature of the testator or testatrix, the one again making the will, as well as witnessing the signatures of the witnesses. This way, when the executor goes down to City Hall to probate the will, they don't have to bring people with them. They can just bring the will, because the notary has already verified that the testator or the testatrix is who they say they are, and that the witnesses are who they say they are and did witness the signature. So we provide instructions to the person writing the will, and we also give them instructions to give to their executors. So there's a letter to executor and a letter to the alternative executor. They are exactly the same, just telling them what their job is and how to get this thing done, what your role is as an executor. I like to tell people to have a dinner and explain to your heirs, hey, here's my will, here's what I decided to do, pass out copies, have the conversation now. I've had one guy say, no, I don't want to do that. I'd rather than just figure that out after I'm gone, because he knew there would be conflict. He had 2 houses and 3 kids. But better to explain, hey, here's why I divvied it up the way that I did, because people will feel some kind of way and you won't be around to explain it. So by explaining it on the front end, explain, hey, you're the executor, here's some instructions. Here's why I gave this one the house, but hey, here's why I left the bank account to you. You're trying to reduce conflict. You're trying to leave things in a peaceful way. So that's the will. Some situations to watch out for with the will. Let me go back to this. So sometimes we have a person come in with their elderly parent, and the son or the daughter is sitting right there. And sometimes we have to kick that person out. So maybe they're there through all of it, but then we might kick them out of the consultation to go over the will with just the testator, because we want to make sure that what's in the will is what they want in the will and that they understand it. Whereas the younger person in the room might be like, yeah, that's what she wants. You want to really make sure and really assess and use some discernment, make sure that you're getting the story from the person whose will it is. So some scenarios we see that are not covered in our template that you might have to put some extra language in, which we will help you with. A life estate. So let's say I want to leave my house to Joan, but Bob is living there, and I want Bob to be able to live there until Bob dies. But then when Bob dies, I want Joan to have the house. That's called a life estate. I want to give a life estate to Bob. You can do conditional life estates. I want to give the house to Bob and let him live there as long as that's his only home. But if Bob buys a second house, that life estate has ended, and now Joan can take the house. So we have this language. We can help you with this language. Like I said, we have folks in our network who do this. And so they've helped us develop language for each of these situations. It's just not in our form template because it's not super common. We see folks who want to direct that the house be sold. It is generally a less good idea to have a house and leave it to 6 people. Because what happens is one of those 6 people will want to live there. or rent it out or make use of it. And the other 5 don't care to do that, but they're attached to it. So if it goes down for taxes or it goes down for any other reason, they all are affected, but there's just the one of them benefiting from it. So it gets hard to figure out, okay, who's responsible for the bills? You are getting some benefit, but one person's getting more benefit. So a testator might say, I want to leave the house to be sold and then split up 6 ways, instead of just saying, I leave the house to someone. That's really easy language to add in. And then I mentioned this earlier, cutting a child from a will, easy enough. You say the children you have, and you say, I leave what you want to leave to whoever you want to leave it to. The more common, the scenario for which, again, we have language, but it's not in our template, is where you have an heir who is disabled, or they, like maybe they're disabled, like they don't have capacity. You wouldn't want to leave them a lump sum of money, whether that's for age, maybe they're on drugs. We see this pretty often, that somebody's just in their addiction, and so the testator doesn't want to leave them money right now. They might want to leave it to someone in trust. Hey, this goes to Tim in trust. Dan is going to be the trustee who can give Tim money as he sees fit. And he can end the trust whenever he thinks that, I forget my names now, whenever he thinks that Tim is doing okay. Or one of your heirs receives SSI, they have capacity, but you don't want to leave them a lump sum of money because it's going to mess up their asset analysis by Social Security. You don't want Social Security to be cut off because they inherited a few $1,000s. So you're going to want to put their inheritance in a trust so it doesn't mess up their eligibility for SSI. So that's another reason somebody will want to leave things in a trust. Healthcare power of attorney. Purpose, to plan ahead, give a specific person the authority to make medical decisions for you in the event you become incapacitated and unable to verbalize what you want. Like I said earlier, it prevents fighting, and it prevents a caregiver from being unable to access medical information. So we're gonna hop over to that template, but say a few things about it. It includes the option to give directives about your treatment or to not give directives and just give all the power to the healthcare agent that you choose. The things that you'll ask them about are, do you want cardiac resuscitation, yes or no? Do you want artificial or invasive forms of nutrition? Do you want kidney dialysis? And you'll just say yes, no, yes, no, yes, no. You don't have to. You can just leave all of that in the hands of your agent. That's the person you're choosing to make decisions for you. But you'd be doing them a favor to give them some direction. So let's go to the healthcare power of attorney. Give me a moment. All right, so I didn't make up any fun names in this one. So the agent is the person you're appointing to make these decisions. This is a really easy one. You're putting their name, their contact. Like I suggested with the wills and the executor, you want to choose an alternative agent. Maybe Erica, the first person you pick, moves to Florida. She's not going to be that much help if you're in Philadelphia. So maybe choose a secondary. This is where you can either give the agent authority to withhold or withdraw life-sustaining treatment, and as well as to give them the authority to make these decisions about nutrition, hydration, artificially administered nutrition, hydration, or you cannot give them that authority and tell them exactly what you want in this very brief living will section or healthcare directive. If they don't check these things off, then you might get that form of treatment with the decision being made by your agent. So an important distinction between this and the financial power of attorney, this is only effective. A will is effective when you die. It has no power until you die. A healthcare power of attorney has no power until you are incapacitated. Financial power of attorney, which we'll talk about in a minute, has power as soon as it is signed and notarized. So it's a very important distinction to make clear to clients. And another good reason to make sure that you are talking to your client and not to your client as well as their son and anyone else. Nomination of a guardian. So this is if in the future, after they make this document, somebody makes a call to PCA, and PCA might say the Pennsylvania Corporation, Philadelphia Corporation for Aging. PCA says, oh, we need to file a guardianship petition. This person isn't being cared for. Let's file a petition. With this document, you're letting the courts know, I've already chosen a person. If someone ever thinks I need a guardian, I designate this agent to be that guardian rather than some court-appointed lawyer you've never met. And then because we're talking about these different forms of treatment, the last part of this document just goes and defines each of these types of treatment. And it also describes the conditions one has to be in for this to be effective: end-stage medical condition, permanently unconscious. So all of these terms are defined within the document. So you don't have to make anything up. You don't have to Google. It's in there. And so that's that. Let's go back to the PowerPoint briefly. All right. So financial power of attorney, like I said, is important to think about this one a little bit differently than the other two. The other two, you're making in the event that you die, which you will eventually, but you're making in the event you become incapacitated. That may never happen. You may never need your healthcare power of attorney to actually take effect, but it's there just in case. Financial power of attorney, different power. It's a lot of power, and it takes effect as soon as you have the notary and witnesses and you sign it. Its purpose is to give a trusted individual the right to make decisions about your finances, do your banking, manage your real estate, sue on your behalf, respond to lawsuits on your behalf, buy groceries, and even care for your pets. It's as broad as you want it to be. You check off each type of power that you want to give to someone, and it defines those powers. So let's take a look at that. Here we go. So the financial power of attorney includes this 2 pages, 1.5 pages of warning. So you have to read this aloud when you are having them sign off, because it's letting you know, hey, this is huge. This is a lot of power. And we've had people abuse this power. We've had people come in and want us to transfer the title of mom's house to themselves. That is not something we're going to do. If you come in as the power of attorney for your mother and you want us to transfer title of the house to you, we're gonna have some red flags about that. How is that in the benefit of mom for her to transfer title to you? People abuse power of attorneys. So we want to really be clear with the person, with our client, hey, this is a lot of power. So be really sure what you're doing. You're the principal, you're the person who is making the document, and you're again appointing an agent. You're appointing a successor agent in the event that that agent resigns, dies, or is otherwise unable to serve. The effective date is effective immediately and shall continue if I become incapacitated or disabled. There's not any original writing in this document at all. It's good for you to know what's in here, but there's no original writing at all, ever. With your will, you might have to do some stuff. With the power of attorneys, what's there is what's there. So this is the different powers. You don't have to make anything up. You do not have to Google. They are all defined over here. So this is one that you take a lot of time to review. This is one that maybe you have 2 meetings. You have 1 meeting to explain what it is, and you have a second meeting to go over it again and then have them sign off on it. Because I like to have a meeting with the principal, the person making the document, and then another meeting with the principal and the agent that they're choosing. So this only gives the powers that they check off to their agent. We're not going to read through the whole thing. But interestingly, right, liability of the agent. So the agent isn't liable for anything that they do poorly. If they decide, hey, I could really expand their assets if we buy the stock and that stock blows up in a bad way, they're not liable for a mistake. They are liable for willful misconduct or gross negligence, like transferring a home into their own name. It has to be, they have to believe that what they're doing is for the benefit of the principal. They're not required to make your assets produce income. They're not required to grow you. They're required to act in your best interest. And if you have a successor agent taking over for a prior agent, that successor is not liable for what that prior agent did. Yeah, this is just really the key here is to go over it carefully and maybe even plan for 2 appointments and to plan a meeting with the agent in addition to the principal. Okay, so tying it up here, I'm going to go back to our PowerPoint briefly. So some situations to, that's not what I meant to do, situation to watch for. Like I said, the will is effective when someone dies. The financial power of attorney is effective as soon as it is executed. That is distinct from the other ones. So just make that very clear to the client that the will has an effective date. It's on the other side of death. Healthcare power of attorney has an effective date. It's when you're incapacitated. Financial power of attorney, effective right now. All right, so here's the things to look for. I'm trying to get a power of attorney for my mom. I'm talking to Leslie. I can't make a power of attorney for her mom who's not here, right? The person who wants power of attorney has to be the principal, not the one who wants to be agent. Often we get a client who wants to get power of attorney with their elderly parent, good intentions, sometimes not. In either case, I practice to arrange to meet with the parent one-on-one, the one you're trying to be power of attorney over, have her come in. Our receptionist is great at deciphering this. We don't want to meet with the daughter or the son. We want to meet with the person who you're saying needs a power of attorney. In that meeting, we have to assess capacity and whether that individual really understands what's happening and whether they really want to make a power of attorney. Now, if the parent's with the client, that's different. Often you have elderly, especially in virtual clinics, you have your elderly client and you have 30-something, 40-something-year-old, child. And like I suggested earlier, sometimes you have to have the client leave while we meet with the parent so you can make an assessment of whether they have capacity to make this kind of document. If not, they might have to make a new appointment if we can't get that done with the adult child in the room. And sometimes it's guardianship. Sometimes, you want to get power of attorney for your mom, but your mom's already too far into dementia, and we actually need to talk about guardianship. All right, my dad wants to change his will, or my dad wants to add me to the deed. We get this one not unoften, and it's super fun to tell people like, no, that's not how it works. Your dad has to come in and want to change his will. You can't say he told me, and so I want to make that happen. I'm helping him out. Or my dad wants to add me to the deed. The dad has to come in, and we can talk to dad about what it is to add someone to the deed. No one can change a will except the testator or the testatrix, and no one can change a deed except the owner. We have to instruct the client to have their dad, their parent, make the appointment with us, and then we make sure we're meeting with just him so we can assess for capacity and undue influence, right? If the person who makes your meals and picks up your medication and gives you rides, if that person you're pretty dependent on seems to be exerting an undue influence, we have to be aware of that. And I went out of order here and mentioned the person who is in need of a POA or a will, power of attorney or will appears to have capacity, then the caregiver may have to pursue guardianship, which is something that we do assist with when we find that it's really necessary. And that's it. Now you're all ready to do an estates clinic or see a client in regular clinic who needs a will or any other kind of estate planning document. And we're always here to help. So you never have to feel the pressure of figuring it out in that consult. You can always say, hey, we're going to get back to you. And we're here to consult with before, during, and after a consult. Thank you so much for volunteering.